Hi, thanks for joining me for this module on students and parents who are immigrants or not proficient in English. There's so much overlap between these two issues that it only makes sense to put these two together. As always, this presentation is based on federal and state statutes, regulations, and case law that are current as of August 2023, so please be aware of changes and updates. This presentation provides legal information, not legal advice. For case-specific advice, please contact Stephanie Johnson at the Tallahassee office using the information on your screen. So in terms of a legal basis, there are separate bodies of law, but there's, again, a great deal of overlap. Specific to immigration, we have Plyler v. Doe, an absolutely earth-shattering Supreme Court opinion from 1982, and the Privacy Act of 1974. In terms of language, specifically English language, we have a bit more. We have Title VI of the Civil Rights Act of 1974. We have two great cases, Lau v. Nichols from the Supreme Court and Castaneda v. Picard from the Fifth Circuit. We also have the Equal Educational Opportunities Act and the Florida Educational Equity Act. Lots of rules on this. I am not going to read these to you, just here for your reference, all of them from the Florida Administrative Code. Let's start with the Florida Constitution. In Article 9, Section 1, it states, "The education of children is a fundamental value of the people of the state of Florida. It is therefore a paramount duty of the state to make adequate provision for the education of all children residing within its borders. Adequate provision shall be made by law for a uniform, efficient, secure, and high-quality system of free public schools that allows students to obtain a high-quality education." This is the basis for Florida's principles. You note that it is all people and all children, not children of residents, not children who are citizens, it's all children. This section has been litigated and has not proven to be particularly strong, but it's always nice to know that it is in the Constitution. The reason that it hasn't been found to be particularly strong is that courts have said that it is very difficult to determine what an adequate provision is. We could argue about that for a long time, probably. In Title VI, which is all about national origin, it's the protection of national origin, which of course is a protected class under the US Constitution, requires education departments and school districts to take action to remove language barriers for ELL students and their families. ELL stands for English Language Learner. And as you can see, the US Department of Education's Office of Civil Rights, which I also refer to later in the presentation as OCR, has consistently upheld these rights. This particular statistic is from an old case of OCRs, and English learners now constitute a much larger percentage of all public school students. Unfortunately, we still have issues. Then there's the Equal Educational Opportunities Act, which is in Florida statute. No state shall deny educational opportunities to an individual, again, race, color, sex, or national origin, by the failure to take appropriate action to overcome language barriers. So it's all about removing the barriers that prohibit or make it more difficult for a student who doesn't speak English to access instruction. So Plyler v. Doe, great case, very old now, but it found, and this is, it comes up all the time and people say, yes, but Plyler. So Plyler v. Doe found that undocumented children residing in the United States have an unqualified right to an education, right? Unqualified, no conditions. So the specific holdings were that because the kids were in the US through no fault of their own, they're entitled to the same educational opportunities. So schools may not deny or discourage enrollment, and those students are eligible for other related services like free and reduced price meals, special education, school-sponsored events. If this sounds a little bit like the argument that the Dreamers make, you would not be wrong. So who is this law applicable to? Who has to do this? Any public institution. Please remember, for federal purposes, charter schools are public schools, and private schools and institutions that are direct recipients of federal funds. So this is a follow the money case, as is the case with much federal law. So let's look at how many Florida students are immigrants. Well, in our region, the Appalachia region, it's about 13%. And as you might imagine, it's much higher in other parts of the state. The poverty rate for those students is about 44%, and the majority of those students, although certainly not all, come from Mexico or El Salvador. You could always look for more current statistics. And just as an FYI, Spanish is the largest group of language speakers in Florida, followed by Haitian Creole and then Arabic. So how does this work at the school level? Well, first of all, you cannot deny a student admission. You cannot treat them differently to determine their residency. You cannot, anything that chills the right of access is prohibited. You cannot require students or parents to disclose or document their immigration status. You can't ask students or parents questions that might inadvertently reveal their undocumented status. You cannot ask for a social security number. And that applies to any student because, of course, if you have social security numbers from these 15 students and then not from these 10 students, you run the risk of exposing the group without social security numbers as undocumented. So this is a don't ask, don't tell scenario. We do not go there. So how about free and reduced price lunch applications? There is a very common belief, it's wrong, that students must have a social security number on the form in order to apply for these benefits. And that's absolutely not true, because we have the capacity to assign school-generated numbers in place of a social security number. So if that ever comes up, that is the answer. You generate a school number. Every student in Florida has a school identification number. There you go. The whole issue about school lunches is related to something larger called the public charge. And as immigration policies in this country have gotten very heated in the past few words, this comes up a lot. So public charge is essentially part of the calculation that's used to determine whether an immigrant can gain citizenship. So many immigrants choose not to participate in public benefits programs for which they are eligible under the mistaken belief that if they participate, they will be prevented or slowed down from their ability to get a green card or permanent residency. This rose to the top of people's attention during the Trump administration, and then the Biden administration withdrew this particular regulation in January 2021. And the whole argument obviously is, why should these people become citizens? We're going to have to support them. They're a burden on society. Well, here's the deal. Immigration is based on the totality of an individual's circumstances. It is not solely based on the use of public benefits. And by the way, if you're undocumented, you can't participate in any of the programs that are considered in the green card review. So obviously school lunch is not in that list. And that includes even if they're married to a US citizen or have citizen children. So when it comes at least to free and reduced price lunch, if it's possible, you need to help people understand that this is not linked to immigration and those processes. There's a lot of anxiety around this. I recognize that, but for your knowledge, they're not connected. So in terms of Florida students who primarily speak languages other than English, It's 10% of all students. Florida is number 3 in terms of English learners. The students in Florida schools speak 300 languages. And in the last school year for which data were available, students tested for language proficiency, only 18% tested as proficient. That is extremely low. That is extremely concerning. Just by the by, terminology about this has changed over time. It started with limited English proficient, then we moved to English language learner. Currently today we use English learner, but obviously in older statutes and publications, you will find any number of variations. So what does this mean in terms of what a school district is obligated to provide to an English learner? Well, first of all, they need to be correctly identified as an English learner. And why I've said not surname on this slide is that we have found in a number of places that if you had a Hispanic surname, you automatically were considered to be an English learner. And then if you didn't, you weren't. And that is not helpful for either category of kid. So please, if anybody is saying, oh, her last name is Diaz, so she must be a Spanish speaker, please question that. Districts are obligated to provide adequate services and assessment. They are required to be accountable for the progress of students in learning English, and they are accountable for exiting students when they meet appropriate benchmarks. So how do we figure out who is an English learner since we've decided that Diaz is not the be-all, end-all? Well, districts send home a home language survey. And that language survey asks just a few questions, including whether a language other than English is used in the home, and whether the student had a first language other than English, or does the student most frequently speak a language other than English? And those are basically red flags. If the answer is yes to any of those, the student needs to be tested. And in Florida, we use a test called WIDA, which is also called Access for ELLs. And it tests students in 4 domains: speaking, reading, writing, and listening. Once a student is determined as being an English learner, they are entitled to English language services. So adequacy is a difficult question. The US has a very long, very difficult history in this area. And there are 2 key cases that I want you to hear about because, honestly, because these situations continue to repeat, but also because you can always go back and say under Lau or under Castañeda, because these are very strong cases. So in Lau, it was in San Francisco, and there was a set of Chinese American students. They just threw them into regular classrooms, mainstream classrooms, and as the opinion states, they were just left to sink or swim. And what did the district say? Hey, we are not discriminating. In fact, we're doing the opposite of discriminating. We are doing exactly, giving them equal treatment. They got the same thing that every student gets. So we've met our obligation. And the court ever so slightly disagreed. Said, look, if you treat people with different needs the same, that is not equal treatment. And so discrimination on the basis of language is discrimination on the basis of national origin, falling under Title VI of the Civil Rights Act. And this was then codified by the Equal Educational Opportunities Act of 1974, which we call the EEOA, which sort of sounds like I'm going to start singing about Old MacDonald and his farm. And what does it say in Title VI? Well, this is very similar to the US Constitution. We are not excluding or denying the benefits of or subjecting to discrimination on the basis of race, color, national origin. You take the federal funds, you can't discriminate. Then we have Castañeda. So Castañeda was in Texas in the Raymondsville Independent School District in the Rio Grande Valley. And at the time, the community was extremely skewed towards Mexican American students. So 77% of the community, 75% of the students. And yet the school grouped these Mexican American students together and put them in different classrooms. together without English speakers. And then they didn't really teach them to speak English. They didn't use any bilingual programming. So they weren't left to sink or swim by being treated the same. They were left to sink or swim by being treated differently. And Castaneda actually said, all right, look, this Lao stuff, you know, how do you expect us to comply? There's no way to measure what is an approach to overcoming language barriers. Well, the court didn't like that one. It said, all right, fine. You want to know how to measure? Well, here's a 3-pronged test. You should have a sound approach. You should reasonably implement the approach, and you should look at your outcomes to see that the approach is working. So there, you can measure it. Yeah. This area continues to be tested in the courts. Newer cases are much weaker than Lau and Castaneda. And as I've said here, essentially the law of the land is you have to do something. You can't do nothing. It's unfortunate, particularly as our demographics change, that we're finding weaker laws. But again, we'll get to in a minute, Florida's context, which is slightly different and stronger. So when the Office of Civil Rights reviews a case alleging inadequate services for English language learners, this is what it looks at. Is the program design educationally sound? Was it implemented right? Is it actually being used with all the students? Does it have the right kind of teachers? And are there exit criteria? And you can look here, they're looking for affirmative steps. It's not okay to do nothing, and it's not okay to wait till someone comes to you and asks. This is a proactive standard. And this is not a standard that is limited to students. It also applies to the parents of students with limited English proficiency, or of course, parents who themselves have limited English proficiency. Schools are required to provide translation or interpretation of all documents and communications, not just the really super special, we're expelling your student, or the really important thing. We talk about parents' rights, and it is the right of a parent to direct their child's education. And so it is also a right of a parent to understand what's going on in that student's classroom. So they need to receive everything in a language they can understand. This was affirmed in Lao, reaffirmed in OCR guidance, and then consistently in OCR decisions. So this can take the form of a language line or literal translations, but you don't just send it out in English and say, I'm done. All right. So this actually has been examined by OCR in a number of cases, and 3 that are very similar are Cleveland, Tulsa, and Dearborn, which is in Michigan. And the alleged offense was the district failed to provide, in this case, you can see it's an older case, limited English proficient parents with information concerning activities and other school-related matters in a language they could understand. So what did OCR say? Well, first of all, they said, yeah, that's a violation. And then they said, you have to develop a plan. And I'm giving you this language so that you can see, sometimes it's helpful to remind districts that it's more work to comply on the back end and fix things than it is to do it on the front end. So these are very thorough agreements. Another common misbelief that is out there is that students cannot be dually served. They cannot be an English learner and a special education student. They cannot be an English learner and a gifted student. Well, guess what? It's one kid and all the laws apply simultaneously. So the student gets all the rights. And in this slide, you can see they get to learn language and they get special ed services. You don't pick and do one first. One kid, all the benefits. And then in terms of exit, the state of Florida has standard cut scores, and you can see that in grades K to 2, it's proficiency on a language acquisition test. And in grades 3 to 12, a student has to achieve a passing score on the English language arts assessment or a concordant exam sufficient to meet graduation standards. So not the point of this presentation, but a concordant exam is just another test like the ACT or the SAT that Florida allows as another way for students to graduate when they cannot pass that Florida test, the ELA assessment. We also monitor EL progress. So just because you pass that assessment, did you pass it by the skin of your teeth? Do you still need services? So we look for 2 years and we make sure that they continue to make progress. This is also something that gets tackled by the Department of Justice. And so one case was in the Crestwood School District in Michigan, where the students alleged that there were not sufficient language acquisition services and, hey, no translation or interpretation services to special ed students. Okay, not so good. And so they ended up with a consent agreement, which you can see, as is in the prior case, a lot of things to document. And OCR is very good about making people document things and checking to make sure that they're being done. If you violate a consent agreement, it's a kind of a big deal, but it's limited how you fight it. So if you violate a consent agreement, the violation has to be brought against the original party or parties. And that comes up in Florida in a specific manner, and we'll get to that in just a second. And the agreement can be modified as long as the court approves, and it is enforceable, again, against the original parties in court. So Florida has one of these fancy consent decrees. It's several decades old, but it continues to shape the education that we offer to English learners in Florida. So in 1990, the Miami associations that worked with families were about to file a lawsuit against the state. And they alleged constitutional violations on behalf of students who didn't speak English. And basically, they said, look, you have like this one program in Miami, and it turns out that there are students who don't speak English all over the state. So that's not enough. And you're not doing anything for our kids who are coming into the country. You have no, established way of identifying students. There's nothing you're requiring in terms of services. You're not requiring teacher training. Basically, this is all pretty awful. And you need to fix it, and you need to fix it now. So instead of going to court and suing, the state of Florida agreed to a consent agreement in a court of law. And the holding was basically, as you can see, that all limited English proficient students are entitled to equal access to all programs appropriate for their academic needs. And, it was like, and that means, if you need to catch up, if you need special ed, if you need vocational ed, if you need adult education, if you need early childhood education, anything in the education system should be offered to you, and you should be able to access it. And there are actually, there's a very, very comprehensive agreement. We won't go through all of it today, although I have slides on it for your reference. So there's 5 primary areas of focus: identification and assessment. And you can see we just talked about the fact that we use a home language survey and a standardized assessment to test kids and make sure that they need services and that they're making progress. Equal access to programming, equal access to categorical and other programming. That means special programs like Title I and special education, reading programs, anything that's sort of called out in the Florida budget or as a federal program falls under there. Personnel, how do we have to train our teachers? How many teachers do we have to have? Monitoring, and then outcome measures. And I just want to flip through these slides so you can see what falls under identification and assessment. equal access. So one thing you can look at when you have an English learner student is what the district plan is. These are not great plans. You have to call the department and ask for these plans, but they are something against which you can hold the district accountable. You can see equal access to educational programming here, access to intensive English language instruction, and not instead of, and their subject matter. They also need ESOL instruction. So if they're using English as English for speakers of other languages, these are so there's several different models that are used to teach students English, and ESOL is one of them. As you can see, if you are in a basic subject classroom, you need to have access to an individual proficient in your language in addition to a trained teacher. Well, that's not practical for every classroom. So what we've got in the decree is that if you have a school with at least 15 students speaking the same language, then you get a speaker in that language. There are small districts that will do anything to have 14, not 15, but definitely worth looking at. You can see the basic requirements of classifying students and of what these programs need to provide. There's also, within the consent decree, language about communicating with parents. Parents' primary language. Hey, let's make sure that parents can understand what's going on at school. There are specific requirements. You have to have a parent leadership council at each school or the district, and you have to provide leadership training and orientation so that speakers of other languages know and are prepared for serving on school and district advisory committees, boards, you have it. Here are the standards on personnel training and certification, which has changed over time, but is now a requirement for every single teacher. This is not just teachers of language. If you are a math teacher, you have to have this amount of hours. If you're a science teacher, a social studies, if you're a guidance counselor. There was a modification about 20 years ago, and it basically traded the number of training hours for passing a state certification exam. Not a big deal, it just added a little flexibility. And as you can see, the Florida Department of Education is actually required to monitor districts for compliance, equal access, and program effectiveness. It is not clear how this is done. No outcome measures are published. There's not an annual review. However, there is a complaint process. And so any interested person, don't have to be a lawyer, can file a complaint. The DOE has 60 days to investigate and report its findings. The DOE does not maintain a list of complaints or a list of resolutions. We have asked. I think this is an area that is ripe for pursual, but we need obviously to make sure first that all of our clients are getting the services they need. Finally, English language proficiency is a component in Florida's accountability system. So we all are probably familiar with the fact that Florida gives out grades to its schools. You can be A school, you can be an F school. But when you do that, it considers all the students together. It just averages everybody's score. But the federal government, when it created the latest version of K-12 education law, was really concerned that kids would get lost in this average. And so the regulations require states to consider each student subgroup separately. And so there's a separate English language proficiency indicator, including in what's called the federal index. I will not go into how the federal index is part of the accountability system because you will hate me forever, but I will show you that this is the basic index. You can get up to 8 components. How exciting is this? So 2, 3, 4, 5, 6, 7. I don't know. Oh, I see. It's because achievement and learning gains are considered separately. So somewhere in here, so for each student group, for Black students, for white students, for Hispanic students, for Asian students, the state looks to see how is the school doing on these areas. And you can see how they're scored. Sorry, that's the 8th one there. The 8th one, English language proficiency, the progress of English language learners in learning language, the English language. There are some resources I just want to leave you with. And here is SALA is the Student Acquisition of Language Achievement, I believe, but that is the bureau within DOE that handles all of these issues. Also, there is a parent hotline. So if you have a parent who has a question about the education of their children, you can always direct them to the hotline if they speak Spanish or English. Otherwise, you'll need to arrange for a language line or an interpreter, but that is a direct outcome of the compliance agreement is this hotline. So absolutely make sure the parents know about it. I know that this is a lot. Thank you so much for hanging out with me and talking about the intricacies of language learning. And I hope to see you again soon.